Mike, have we got everybody from the outside that wants to come in?
Everybody, and it should be.
Okay, and certainly if more come in, we've got plenty of seating for them now, so they can come in as they are ready. Ladies and gentlemen, this Court of Appeals sitting in Huntsville, Walker County, Texas, and we are pleased to have you all here today. There is a 10-minute spiel that I went through in connection with the first case. It explains what is different about today than a normal court proceeding. In the interest of time, I am not going to go through that again with an exception or two. I will say that District Clerk-elect Leslie Warrior, but she is now, so Ms. Willie, good to have you join us today. Also, the photographs. Normally, we don't let folks take photographs of the court proceeding while it is going on. A lot of technology has changed since that rule was passed, and the flash bulbs involved, you had to get close and all that kind of stuff. We allow you to do that now, but we ask you to stay in your seat, not use your flash. As a result of something that happened in the last the interesting thing is I had forgotten to announce, make sure your phones are in the off or silent mode so that it does not distract from the arguments of the court or the person making the argument. The second case that we are going to hear today, and I'll ask for announcements from the attorneys that are going to make the arguments, and then the whether or not there are any issues that need to be taken up before the argument begins, is it's a mandamus case, and I'm hoping that counsel will explain the difference between a regular appeal. If not, you can ask a question later, and we'll talk about that. But in re the state of Texas, and I will now take announcements from the council.
Will Wasdorf, Your Honor, with the Attorney General's Office for the state of Texas.
And you go by Will?
Yes, Your Honor.
Okay. Thank you, counsel.
Holly McIntosh, Your Honor, with Thompson and Norton on behalf of Waco Independent School District, La Vega Independent School District, and their respective defendants and board members.
Thank you, counsel. At this time, the state will have 3 minutes to address the audience. This is not something that you would normally see in the proceeding in Waco if we were holding these arguments there. This is to help you all, the students, understand what is about to happen. Counsel, you may proceed when ready.
Thank you. Ladies and gentlemen, I represent the state of Texas. As the Chief Justice just mentioned, this is a mandamus proceeding. It's an original proceeding. It is not actually an appeal. A preliminary order was issued by the trial court from which we do not have a right of regular appeal. And so we are asking this court to basically order the lower court to overturn the decision. Now, the subject matter of this case is face mask requirements from COVID-19. Way back in March of 2020, the Texas issued an executive order, the first executive order, responding to COVID-19. Later that summer, I think in July, he issued an order requiring people to wear masks. Fast forward about a year to August of 2021, and he issued an order prohibiting local governments from requiring people to wear masks. Shortly after that order was entered, local governments across the state filed suits against the governor, the attorney general, and the state of Texas, challenging the validity of those executive orders. One of those suits was filed in Travis County by several school districts. A couple weeks after that, the state of Texas filed suit against some other school districts, challenging their local orders requiring masks as exceeding the effect of the school districts in light of the prohibition. prohibition contained in the mask mandates. We are here today on an issue of dominant jurisdiction. The lower court abated the state of Texas case against Waco and the Independent School District in favor of the case pending in Travis County because arguably they deal with the same subjects. We believe that the case in McLennan County, where Waco is located, should have been allowed to proceed, and we're asking the court here to order the trial court to proceed with the case.
Council, you may proceed when ready.
Chief Justice Gray, Justice Johnson, Justice Smith, may it please the court. My name is Will Wasdorf, and I represent the state of Texas in this petition to writ of mandamus. This mandamus proceeding is about the abatement of a suit filed by the state of Texas in McLennan County regarding the face mask requirements implemented by Waco and La Vega Independent School Districts in response to COVID-19. Respondent abated that suit in favor of another lawsuit filed against the state by other school districts in the state of Texas on other grounds in Travis County. So this court should issue the writ for 3 reasons. First, venue is mandated in McLennan County by Section 65 Civil Practice and Remedies Code, and therefore is not proper in Travis County. So the dominant jurisdiction question should never have been reached. Second, there is no inherent interrelationship between the subject matter of the McLennan County suit and the Travis County suit. And third, by denying an anti-suit injunction in the Travis County suit, the Third Court of Appeals has already determined that the McLennan County suit does not interfere with its own jurisdiction or that of the Travis County Court. Despite its name, the dominant jurisdiction doctrine is not a jurisdictional rule, but rather a venue rule. It resolves the conflict when 2 lawsuits are filed in separate counties dealing with the same subject in courts that both have subject matter jurisdiction.
Let's talk about subject matter jurisdiction first. Anybody that sat through the last case knows that we have to focus on jurisdiction first and then might get to the merits of the case. Does it matter to this proceeding whether or not the school districts currently have mask mandates? Is it moot, is the question?
Yes, Your Honor. I believe it is not moot. First of all, La Vega Independent School District, in this case, as far as I am aware, still does have a mask mandate. Waco Independent School District, while they have rescinded their mask mandate, the superintendent has been quoted in the newspapers as refusing to not re-implementing the mask mandate if COVID worsens. We would argue it's capable of repetition, yet evading review. As we've already seen, the city of Philadelphia recently re-implemented its mask mandate. And so we believe for that reason that this is not moved.
Okay.
So for the dominant jurisdiction doctrine to apply, first, venue must be proper in both counties in which the suits have been brought. And second, the 2 suits must be inter. So that brings me to my first point. Respondent abused her discretion by abating the McLennan County suit in favor of the Travis County suit because venue is not proper in both counties. Venue is not proper in Travis County because venue is mandatory in McLennan County under 65.023. 65.023 of the Texas Civil Practice and Remedies Code requires that, quote, a writ of injunction against a party who is a resident of this state shall be tried in a district or county court in the county in which that party domiciled. Unlike the dominant jurisdiction doctrine, Section 65.023 is not just a venue statute, but is also jurisdictional as to those claims. To invoke the mandatory venue provision of 65.023, the relief requested must be primarily injunctive. meaning that it is, the injunctive relief is first in order of rank or importance. But that does not mean that that can be the only relief. We have also declaratory relief, but that declaratory relief just mirrors the injunctive relief and would not be sufficient on its own for the state.
I want to be sure I understood what you argued there, that the venue statute in this instance is not just venue, it is also jurisdictional.
Correct, Your Honor.
And is that by the statute or case law, or where do you get that argument?
It's by the language of the statute and case law. This is not in the venue provision of Chapter 15. This is in Chapter 65, which deals with specifically injunctions. And
So you take the position that even if the school districts wanted to go intervene in the Travis County suit that they contend was the dominant suit, they could not?
the school districts could presumably intervene, but the state seeking injunctive relief could not bring that in Travis County. And the case that we cite in our brief for that position is Boutron versus Cantu out of Corpus Christi Court of Appeals in 1997. So as their sole argument that venue is proper in Travis County, real parties point to the second sentence of section 65.023A, which provides that if the injunctive relief is sought against more than one party, it may be tried in the county in which the party is. But this argument fails to support venue in Travis County for several reasons. First of all, the only parties present in the McLennan County suit are domiciled in McLennan County. There are no parties in Travis County currently in the McLennan County suit. Second, in the Travis County suit, the state of Texas is present as a defendant only and has not brought affirmative claims for injunctive relief against any of those defendants. So even if the claims against Waco and La Vega ISD were joined to the Travis County suit, the only parties against whom the state would have an injunctive request for injunctive relief would be domiciled in McLennan County. To get around this, real parties appear to contend that the state should be forced to amend its claims to create venue in Travis County. But there are a couple problems with that. First, that would lead to the absurd result that the state is required to waive. Let me back up. In the Travis County suit, the state is currently challenging the jurisdiction of the Travis County Court. If the state were required to amend its suit to bring in the McLennan County defendants and request injunctive relief against the existing plaintiffs in the Travis County suit, the state would have to waive its jurisdiction, in that case, waive its sovereign immunity. And that can't be the purpose of the dominant jurisdiction doctrine. Second, venue in this instance is, venue for the purposes of the dominant jurisdiction doctrine is a threshold issue. There is nothing in section 65.023 that says, well, venue is proper in the county in which the party is domiciled. Things can be amended to create venue in some other county. Moreover, the Texas Supreme Court, in its prior case law, has stated that when venue is not proper in both counties, the dominant jurisdiction question does not arise. Now, we would agree that under the dominant jurisdiction case law, the question is whether the could be added and the claims could be amended to include the the claims in the McLennan County suit. But before you get to that question, you have to answer whether venue is proper in both counties. And the answer here is clear that it is not. Moving on to my second point, Travis County does not possess dominant jurisdiction because there is no inherent interrelationship with the McLennan County suit and the Travis County suit. It is clear that Executive Order GA38 is a share between these two suits, but that is not the analysis for an inherent interrelationship. To determine whether there is an inherent interrelationship, courts are guided by the compulsory counterclaim rule, Rule 97. And several of those factors do not support a compulsory counterclaim and thus an inherent interrelationship between these two suits. First, Travis County does not have jurisdiction over Waco or La Vega ISD defendants. Neither Waco or La Vega ISD are present in the Travis County suit, and the events giving rise to the McLennan County suit did not occur in Travis County. None of the joinder rules would appear to apply here. McLennan County is not a necessary party to the Travis County suit. And the state is currently contending that Travis County doesn't even have jurisdiction over that suit. And as I previously mentioned, section 65.023 is jurisdictional. Second, the state's claims against real parties are not claims that the state has against an opposing party in the Travis County suit. Real parties are not parties to the Travis County suit again, and because the state's claims are based on those claims could not be brought against the parties that are present in the Travis County suit. Third, the McLennan County suit and the Travis County suit don't arise out of the same transaction or occurrence. Courts apply a logical relationship test there. It's about whether significant facts are logically related to each cause of action. Here, as real parties argue, there is a shared significant legal question validity of GA38, but the facts that support the Travis County suit, which is arguing for the invalidity of GA38, and the McLennan County suit, which is arguing for the invalidity of the local mask mandates, are not shared, and therefore they don't arise out of the same transaction or occurrence, and the cases cannot be interrelated, and the dominant jurisdiction doctrine should not apply. Finally, school districts in the Travis County suit, specifically the intervenor school district plaintiffs, have already sought and were denied the very relief which they have obtained from respondent here. In the Third Court of Appeals, they sought an anti-suit injunction based on the dominant jurisdiction doctrine, seeking to enjoin, amongst other things, this very suit pending in McLennan County. The Third Court of Appeals declined to issue that anti-suit injunction and therefore protect its jurisdiction and the jurisdiction of the Travis County Court. And this court should not now allow respondents to purportedly protect the jurisdiction of the court, which the Third Court of Appeals has already determined was not entitled to protection. I would agree, Your Honors, that that decision is not binding in any way on this court, but I do think it is highly persuasive. There is an issue with the adequate remedy on appeal and whether mandamus relief is appropriate in this case. As an initial matter, in Henry J.B. Hunt and Perry v. Del Rio, the Texas Supreme Court has held that mandamus relief is available without proof of no adequate remedy on appeal in dominant jurisdiction cases. There are also cases that say mandamus relief is appropriate when a case is debated for indefinite duration, or in the generic mandatory opinion cases, which this would be. Now, to the extent that we do need to establish that no adequate remedy on appeal, I think the issue here is that as a sovereign entity, the state has an inherent right to create and ensure local governments comply with those laws. The Texas Supreme Court has repeatedly held in these COVID cases that status quo is gubernatorial oversight. There is no injunction currently in place anywhere in the state which would excuse compliance or non-compliance with Executive Order GA38. Respondent has essentially worked an end run around the Supreme Court's stated status quo by abating this case and locking in the status quo that Waco and La Vega independent school districts are being allowed to continue to violate Executive Order and has deprived the state of any adequate appellate remedy. The better solution would be simply to deny our request for temporary injunctive relief in that case, from which we would have an opportunity to bring that appeal. But because of the abatement, we are not afforded that opportunity.
Well, let's play a what if here. If we granted the mandamus, ordered the trial court to withdraw her order,
At that point, the trial court should rule on the temporary injunction hearing, which has
should
already
rule,
occurred.
but we can't compel the trial court to even take it up the issue because they've got a pending motion. Trial judges, let's see, do I still have one out here? Yeah, trial judges have that discretion of when they're going to run their docket and what they're going to do and when they're going to do it. And I heard you mention something about a mandamus when abated indefinitely, but what prevents this trial court from just saying, okay, I can't do what I did, which is base it on dominant jurisdiction, but I'm going to wait until some other court gets a definitive ruling on this question.
I see my time is up. If I may respond to your question.
Absolutely.
So, Your Honor, at some point, the court must rule. And courts of appeals have regularly mandamus trial courts for refusing to rule. It's not a bright line rule as to when that has to occur. It has been many months at this point already. And I think that we would be at the point if the trial court continued to refuse to rule, to seek mandamus again to force a rule.
Okay, a bit, because this is a jurisdictional question, there are some issues that we could take notice of that are outside the record. Can you tell us how many other cases are currently pending across the state involving the mask mandate or the mandate against masks?
I can give you an estimate,
That's fine.
which I would estimate that it's around a dozen. Some on brought by local governments against state entities, some remaining, such as this, brought by the state local governments. Additionally, there are a few cases that I'm aware of where parents of students have brought cases against the local school districts. I'm not aware of how many of those are currently.
Other than the Third Court of Appeals decision to not, I guess you would say, stay the Waco and other cases, do we have any other appellate jurisdiction, decision involving the mask mandate or mandate against masks?
Yes, there are three that I'm aware of. one out of the Fifth Court of Appeals in Dallas, one out of the Third Court of Appeals, which is actually the Travis County suit that we're discussing here, and then one out of the Fourth Court of Appeals in San Antonio.
Anything for us? Thank you, Council. You'll have 5 minutes for rebuttal. Council, this time, I have 3 minutes to address the audience. And it will work best if you'll come to this side and kind of pull the microphone over to you.
Happy to do that.
You may proceed when ready.
Good morning. Thanks for being here today. So what I want to do is, after Mr. Wadsworth explained about what a mandamus is, and I want to talk to you about dominant jurisdiction, just to give you a little bit of background about that, since that's such a major issue. So what this is really about is who gets to decide these issues, which court gets to decide. But more than that, it's also about who gets to decide which court decides, right? And so the rule, the general rule in Texas is the first person to the courthouse gets to decide. So in a simple, easy, dominant jurisdiction case, you're looking at party A sues party B in one county, and then county B, or person B goes to a different county and sues person A. And over the same issues. Like, let's say it's a contract dispute and it's over interpretation of the exact same clause, the exact same issue. That's an easy case. Person B's case is going to be stayed or put on hold, pause, so that the first court can decide if the person A sued first, right? It's a race to the courthouse and whoever wins wins. But it can be more complicated, and that's what's going on here. Here, some school districts, not including Waco and La Vega ISDs, but some school districts sued the state over whether the governor's mask mandate ban is lawful, whether he has the authority to suspend the legislatively enacted statutes, the laws that say school districts get to regulate what happens in their schools and get to enact measures for the health and safety of their students. That's the law that's out there. Everybody agrees that in the absence of this executive order, school districts could do that under those laws. So the question is in the lawsuit, can the governor suspend their ability to do that? So that question was raised in the first lawsuit by different school districts. And then the court ruled in that first lawsuit and said, we're going to grant an injunction pausing the governor's executive order. And in the meantime, and then after that, 2 weeks after that court ruled, the state sued Waco and La Vega and several other school districts at other forums. And so this issue has been raised other places for various reasons ruled on in those other cases, but it hasn't ruled on here. And so what we're keep doing here is talking about, is this the equivalent of an A versus B case? Because it's more complicated, but should it be guided under those same rules?
Thank you, Council, and you may proceed when ready.
Thank you, Your Honor. So I want to start out by noting that under case is not about whether Waco ISD or La Vega ISD executed mask requirements in contravention of the PA 38. They did. That is not contested. And that matters because it colors how we then view the rest of these tests to see whether this is an interrelationship.
Do you agree with opposing counsel, this case is not moot?
I agree that it's not moot because in fact, both the school districts do maintain that they have authority under the Texas Education Code to issue mask mandates, and the governor does not have authority to keep them from doing so. And if the numbers went back up, I think both of my clients would reinstitute their mask mandate.
Let me rephrase my question. Do either of your clients have a mask mandate currently in place?
They do not, and that's important, Your Honor, because what I was going to follow up with is while I do not think it makes the case moot, I absolutely think it it colors the question of whether this is an appropriate case for mandamus, and also whether the trial court, in the equities of the case when you're looking at abuse of discretion.
Expecting a motion to dismiss the underlying suit.
To dismiss the underlying suit, I don't think so. I think that there potentially the appeal could be dismissed because it's not mandamusable, but I don't think that we can dismiss the underlying suit. My understanding of the case law is we would have to commit to not, if there's a voluntary rescission of something that somebody's filed a lawsuit on an injunction, my understanding is that if you can't, that doesn't make the case moot unless you commit to not reinstituting it. Not willing to do that. If the numbers go back up and they think believe it's necessary for the health and safety of their students, they're going to issue a mandate again.
So is it your position that as long as GA 38 is in existence, that this matter is not moved? As long as the governor's order is out there?
As long as the governor's order is out there and it appears that there's a chance that the numbers could go back up, right? I could see that, I could see there being a time at a certain point down the road where something happens with COVID-19. We no longer see mask mandates as a real possibility of needing to be reinstituted. But at this point, I mean, I couldn't tell you when that would be. A year ago, I would have thought we'd be there by now. We are, so. So then the next, I'm going to address the topics in the same order as Mr. Wadsworth, unless the court has a different order that you want me to go in. Starting with venue, I'm going to start with the question of whether this venue statute is jurisdictional. It is not. The court case that they cite to, there are two subsections to the venue statute. Subsection A is the one we're dealing with here. Subsection A is about where you have to file for a writ of injunction. Subsection B is the one that the court case that they are talking about deals with. So subsection B says that that to enjoin execution on a judgment, an action that says you can enforce that judgment, must be brought in the court in which the judgment was rendered is jurisdictional. That is what Boutron says. So it's talking about subsection B and subsection B only. They're saying if you are going to ask somebody to not enforce a court order, you have to go to that court first. If anything, Boutron would suggest that we should be in the Travis County Court, because the Travis County Court is the one who said, and then later the Third Court of Appeals, those are the courts that have said GA 38 is unlawful and cannot be.
You realize that causes me to ask the obvious question: why didn't you go to Travis County and try to intervene in that suit? If you contend that's the proper court, that they have jurisdiction, why are you not there?
We are not there because we didn't bring suit, and we weren't intending to bring suit. We were brought into this unwillingly, and because the Travis County Court had already made its decision, had already issued an injunction, and it was on appeal to the court perfectly well. It was going to work its way up to the Texas Supreme Court, and there would be a final ruling, and that ruling would be what matters, no matter whether we were in it or not.
But you could still go there.
We could. But if we did, I would bet you anything that they would now say the venue is only proper in McLennan County and we have to be pulled back there because they have dominant jurisdiction. And would be.
But the dominant jurisdiction question on an intervener, as I understand it from the briefing, relates back to the date the suit was filed, and that one, if we bring it back under the umbrella of dominant jurisdiction as opposed to venue, then you're there. Travis County predates the Waco filed case, and dominant jurisdiction would then be attached.
Potentially, yes. But I also don't know. I mean, if we're talking about forum shopping, right? And that's what we believe the state is doing here when they lose in one court against dozens of school districts, and then without ever trying to enforce GA 38, under their duty to assert the power of the state over its subdivisions, yet they only assert the power of its subdivisions over in jurisdictions they believed would be more friendly to them. It turns out they weren't, because they only won in one of those jurisdictions. But that was what the court was doing, what the state was doing was forum shopping. And my clients have no interest in being part of the lawsuit. They wanted to wait. They don't want to be part of this lawsuit or any lawsuit. They want to wait on the court case.
Are any of the school districts in the Travis County suit outside of Travis County?
Yes, Your Honor. Several. In fact, only one of the 12 school districts is in Travis County. Well, two of them overlap a bit, but there are other school districts that have been sued by the Attorney General that overlap in the Travis County. But in the Travis County suit, only one of them is in Travis County, and that's Austin ISD. Okay, so then the next question is venue only proper in Methuen County? And I would argue the state's analysis is flawed, because what they do is they ask a different question than we need to be asking. The state asks, if the state were the only party, and if Waco and Lavega was the only plaintiff, and if Waco and Lavega were the only defendants, could they sue in Travis County? The answer there, we agree, is no. They could not sue them in Travis County. But that ignores the rest of the statute. And when they look at the second half of the sentence that says that if a writ is granted against more than one party, it may be tried in the proper county of the county in which either party is domiciled. And they say, well, both these parties are in Waco. But that's beside the point, because you can't you can't do a dominant jurisdiction analysis of venue and completely ignore the first case that was filed. And because that first case was filed and in Travis County against other school districts, or by other school districts, and they could absolutely join Waco and La Vega as defendants in that case if they wanted to. Now, their argument is that they can't do that without waiving their plea to the jurisdiction. There's a couple of problems with this argument. One of them is that basically what they're saying in that first case, their plea to the jurisdiction is saying you can't sue to enforce GA, you can't sue to say GA 38 is unlawful because we aren't enforcing the law. That's what they say for Governor Abbott and for the Attorney General who were sued in that case. But first of all, they could bring this claim only on behalf of the state of Texas and not on behalf of the individual defendants. Second of all, what they're arguing, I would argue that to the extent the state bringing a claim to enforce GA 38 waives their sovereign immunity, they already did it by doing it here. You can't take two completely opposite positions and two completely different lawsuits. The state in these cases, but it's not proper for them to say, you can't sue us, you can't sue to say this is unlawful, but we can sue you to enforce it. Which is an inequitable position. And the other issue is that they could, of course, say that they could make the argument, they could bring the counterclaim subject to the jurisdiction and say this is only if our plea is denied. The other problem with their venue analysis is that they read that first sentence of shall, which does mean the mandatory venue provision, but they then assume that that means it's the only proper venue. And that is not what the law says. So first of all, the second sentence of this statute, as we discussed, if analyzed properly, would say it's not the only proper venue. But second, the case law that says you can have more than one proper venue, more than one mandatory venue can be applicable, and that is the case here. And then if we turn to the interrelatedness, again here the state is ignoring what this case is actually about and what their briefing says it's about, and instead is now arguing that that this is a case that is about about the individual facts, about who in Waco ISD and who in La Vega ISD issued this mask mandate. But their own petition says that cases, plural, turn on a pure legal question. And that is in the mandamus record, volume 2 at page 553. So by their own admission, this is a case about face masks, about who gets to control whether face masks are worn in schools. Is it school districts or is it the governor? Does the provision in the Texas Disaster Act that allows the governor to suspend certain regulatory statutes, does that allow him to suspend any statute he wants to? Basically what 38 says, it says I'm suspending this list and any others that I think might interfere without naming them, right? And so the question is, can he do that? That question, the state believes is a pure question of law. We think there are factual elements to it because one part of the analysis under the Texas Disaster Act is whether the governor's action was taken under the statute, and that involves some factual questions about whether a mask mandate ban mitigates or worsens the declared disaster. But those facts are common between this lawsuit and the other. Finally, and I think most importantly, the reason that this is not a mandamus civil issue and is not an abuse of discretion is because it's exactly what Your Honor talked about when you were questioning Mr. Wadsworth, which is the trial court's ability to manage its own docket. It is not unreasonable or an abuse of discretion for the trial judge to say, look, there's this case, it's ahead of mine. It's already not just on this preliminary issue, but on the question of the merits, because the temporary injunction both raise this question of whether the governor has this authority or whether this part of GA 38 is unlawful. And that's already up on appeal, and we know it's likely to go to the Supreme Court. And that court, it has gone to the third court in the time that this appeal has been pending. The third court agreed with the trial court. The state's deadline to appeal is May 1st, or actually May 2nd, because May 1st is Sunday. So that means by May 2nd, one of two things will happen. Either that case will be resolved, and now it can go to, this case will pick back up because that's what it is. They don't appeal, and that case is resolved. Or they appeal and it goes up to the Supreme Court. And then of course, this trial court is going to want to wait and see what the Supreme Court says about this vital, novel issue before they do. And it's not unreasonable the court could have made that decision. Another thing I would point out, Your Honor, is that you asked the question of what happens when we go back, if we go back down, like you order the court to pick it back up. Actually, the first thing the court has to consider is the school district's plea of the jurisdiction. That before they. So there's a jurisdictional question, an underlying jurisdictional question that is not relevant to this appeal down below that will have to be decided before we get to the question.
So you're saying y'all have pending in the trial court a question of the trial court's jurisdiction?
Yes, Your Honor.
Then why is this order valid at all? I mean, jurisdiction is always the first question.
Yeah, I think part of that is to say, I guess my answer to it will be a practical answer, which is that because all the court did is say, I'm going to put this case on pause and wait to make my other decisions. Because they'll lead to the jurisdiction question.
But did she really say put it on pause, or did she say I'm not going to move forward because of dominant jurisdiction? And that's different, because if she ordered it stayed or abated because of the concept of dominant jurisdiction, when she didn't have jurisdiction at all based on your plea to the jurisdiction.
I don't know if I have a good answer to that question, Your Honor. I would say that what the judge did was grant our plea in abatement, which we filed subject to the plea to the jurisdiction.
Using his argument, why doesn't that waive your plea to the jurisdiction? If you asked for a plea in abatement and got relief from the trial court, why does that not move your plea to the jurisdiction of the trial court? Because you said they don't have jurisdiction, and yet you got relief from the trial court. Maybe tell me.
Well, I don't think it moves our plea to the jurisdiction any more than I think them bringing a counterclaim subject to their plea would. You can file that plea, and then because of deadlines or court hearing or whatever, that doesn't mean that you have to forfeit your other defenses, right? We're not saying that we're not bringing any affirmative claims. What we're doing is saying, we don't believe that you can sue under this, that you have properly pled a claim under an authorized claim against our officials.
Having been a trial judge for over 26 years, I will not admit or deny that I might have let some things wander down the road a little bit. Having said that, how long do you say is too long to let it wander down the road, waiting for somebody else?
I don't know that I have a firm rule on that, Your Honor. I think that it would probably depend, if I were in the state's position, I would argue it depends on how urgent I think my temporary injunction is. In this instance, since the school districts don't currently have a mask mandate and hopefully won't have a need for one before school lets out for the summer, I would say it's not that urgent, so what does it matter, right? But if I thought this was really important and that it was still in place, I would think it was urgent, and I would be doing exactly what Mr. Wadsworth said from our position, because for us, you know, I mean, obviously our position is different. We don't think the court should be ruling on the merits of it. So whether they don't rule because they've stayed the case, or whether they don't rule because they have the judges reached the much more complicated question of their jurisdiction, it doesn't matter to us practically. I would also say that the plea to the jurisdiction, while the difference is it's our plea versus their plea, there are a lot of similar issues going up in the state's plea to the jurisdiction. And so even their ruling on the plea to the jurisdiction, part of that is, you know, it's a plea to the jurisdiction that involves looking at the merits of this case. When we're looking at whether they acted ultra virus, we have to necessarily ask whether GA 38 is lawful. So it's a plea to the jurisdiction that gets into the merits of the case. And it's a plea to the jurisdiction that would be much easier to decide after the Supreme Court gives some guidance.
Assuming.
Assuming they do so. Yeah.
Thank you, counsel.
Thank you.
I did you, was there any other one sentence, two sentences that you wanted to say before you, are you good with where you are?
I think I'm good with where I am.
All
Thank you.
right, thank you. You may proceed.
Thank you, Mr. Court. Let me start out by pointing out something that may not be so obvious. In this underlying suit in McLennan County, there will be no ruling that G valid or invalid. Neither party has brought a claim asking for that decision. You know, the question is whether or not the local face mask requirements are valid or invalid. I
But
agree.
now, but in all candor, isn't that all going to depend upon whether or not GA 38 is valid or invalid? And the scope of
It can, depending on which way things eventually go, presumably at the Supreme Court, may or may not end up back in trial court, regardless of what this court decides. But I do think that is a distinction to be had between these suits.
How could it not be dependent on GA 38?
I'm not saying it's not dependent on GA 38. I'm just saying that that is not going to be an affirmative ruling of this court. This court cannot, in fact, come out and say GA 38 is invalid.
when you say this court, are you talking about?
I'm talking about the trial court. Okay, sorry. Additionally,
And you said that there wouldn't be a way that Judge Menard would be asked to make that determination?
that any express ruling on that issue would be an advisory opinion in this case, because there has been no affirmative relief sought on that specific issue.
doesn't your request to enforce mandate ban inherently rely upon the validity of GA 38?
Yes, Your Honor, but.
And so how could this trial court not reach that issue?
I'm not saying that they can't reach the issue ultimately, but the laws in the state are presumed valid until properly challenged. There has been no challenge to GA 38 in this trial. So the court could rule that he could deny our injunction. But the denial of that injunction would not be a ruling that GA 38 was invalid.
I have to think about it.
Yeah,
But it might be that the school board has the authority to, if they deny the injunction, if judgment are denied, it might be the school board or the school superintendent has the authority to issue that, such a mandate.
correct.
Not that the governor's orders about. Correct. Okay, I see what you're.
Next, I think a good illustrative point is that they are saying that the trial court case should be abated because of the case pending in Travis County. But the case pending in Travis County is not the first filed case dealing with GA 38. That distinction goes to the case pending in Dallas County, Fifth Court of Appeals, and now the Supreme Court, which is Coke v. Jenkins. It's filed. So to the extent that the sharing of the issue of GA 38 is sufficient to invoke the dominant jurisdiction doctrine, the only case that should be allowed to proceed is the case arising out of Dallas County. And none of these other cases should be allowed to continue. But that is, that's just not how the dominant jurisdiction is intended to work. Next, ability of the state to join the McLennan County parties and claims in the Travis County suit. Something that my opposing counsel left out was that even if the McLennan County parties, Waco and La Vega ISD and their officials, and our claims against them were joined in the Travis County suit, there would be no party against whom the state sought injunctive relief who was domiciled in Travis County. Therefore, 65.023 would continue to apply. And then 65.023A, which we rely on, I would argue is jurisdictional. I agree that the case that we cited was dealing with the subsection B provision, but the language is mirrored. So to the extent that subsection B is jurisdictional, subsection A would have to be jurisdictional as well. And for those reasons, we would ask that you issue the writ of mandamus in this case.
Thank you, counsel. This case submitted is excused. If you did cite any other authority that you had cited before, we said normally we say Friday of the week, or Wednesday of next week will be fine. To the audience, I say, and I forgot to put this earlier, if you want to follow what happens in this case, there is a way to sign up for what's called case mail. It's described in the little pamphlet that was handed out. If you didn't get the pamphlet, sign up for case mail. If you have trouble signing up for case mail, call the court at its general number, ask for Nita Whitener, and she will help you sign up for case mail so that you can track that case. So, and that way you'll know when the court issues an order or an opinion in the case, how to find that authority. So thank you all very much for your attention and your interest, and the courts will stand adjourned until 1:30. Thank you.